Thanks, everybody. Really appreciate it. Jordan Torrey from my office is here, and I can really relate to the timing in this business. He's the only lawyer that I know in America whose cell phone number is freely given to clients, particularly drywall clients. So he's constantly on the phone. He's not married, so I guess he's allowed to do such things. But anyway, I would like to sort of give you an overview of the status of the litigation. I'm going to focus on the MDL litigation pending in New Orleans. I'm a co-chair of the medical monitoring part. Unfortunately, that has not really developed because we're still working with property issues, and we're still working with property issues largely because this litigation is a real albatross. There's some great aspects of it. There's great liability, great damages, but the collectability part has been very, very difficult. Russ Furman, who is the liaison counsel, a former president of the American Trial Lawyers Association, has talked about this very issue. It is some of the best litigation I think trial lawyers have ever encountered, and it has its challenges. Seizing ships has been offered as a remedy for some of these Chinese companies that don't respond to the litigation. The MDL came about as a result of thousands of complaints that had been made to the Consumer Product Safety Commission and some of the state health agencies, particularly the one here in Florida, and the environmental agencies as well. What allows this case to be consolidated, even though you have a variety of defendants, you have plaintiffs scattered throughout the Gulf Coast and in Virginia, is that there's a commonality of facts in virtually all of these cases. And because you have a commonality of facts, the federal court system is particularly well adapted to make the litigation more efficient and cost-effective, and that's the purpose of consolidating all the cases for a single judge. The judge that was selected for this litigation is Judge Fallon. Eldon Fallon is a great judge. He was the person who put together the settlement, of course, along with the lawyers in the Vioxx litigation, which was a massive undertaking that has resulted in a $4.85 billion settlement. The litigation was quite successful in that thousands of people have received compensation for heart attacks and strokes. The litigation is still pending because there's some issues that have to be resolved concerning third-party payer claims, attorney's fees, cost reimbursement, etc. But the nice thing about an MDL is that it eliminates inconsistent rulings. You have one judge who calls the shots. That's the good thing about it. It's not a class action. It is really a mass action where you have all of the suits consolidated largely to permit discovery, to allow the lawyers to get together and come up with a game plan, come up with procedures by which the litigation can be made efficient. And then the plaintiffs who are selected for trial are known as bellwethers. The steering committee, consisting of a small number of lawyers, guides the litigation. They put up the money. They're assessed fees, which are used to retain experts and to pay for litigation costs. And they also initiate the lawsuits. And even though many lawsuits may have been filed in different states, the ones that are removed, in virtually all the cases, are removable unless you have a state-based defendant, such as builder or developer. The litigation is put together in the form of these omnibus complaints, and they're identified here. For example, you have Omnibus 1, which consisted of of the NALF lawsuits. Omni 2, the non-NALF manufacturers. Omni 4, now manufactured drywall cases where the initial deadline wasn't met. We're all the way up now to Omnibus 6, which includes insurance coverage litigation. For example, you have policies pertaining to home builders, policies pertaining to developers. You have brokers, importers, exporters, all being brought into this litigation. Not all the coverage litigation, though, has been sent to Judge Fallon for his consideration. Some of it is pending in other jurisdictions. I'm going to talk to you a little bit now about these bellwether trials. And these are test cases. The purpose of an MDL trial really is not to try cases. It's not to see what juries think, but it's really to create a global resolution. The idea is to create issues for a jury to decide that will have some relevance in determining the settlability of the litigation. Because if the cases are not resolved at the MDL level, the judge is duty-bound to send the cases back to the states and federal jurisdictions where the cases originated. All right, there's two very critical cases. One is called Germano versus Taishan, and the other is Fernandez versus Now. I will discuss both. The Germano case really was a default judgment. Taishan was the defendant in the litigation. It opted not to defend. Now, which was not a defendant in this particular case, did intervene initially, believing that there were issues it wanted to protect. It wanted to put forth its position on behalf of itself as well as other manufacturers of drywall. But once the judge granted a doubter challenge to an alternative remediation proposal propounded by Now backed out before the trial, and the default judgment was ultimately entered. Nonetheless, the court did enter findings of fact and conclusions of law, a very extensive analysis of the history of Chinese drywall and the problems associated with it. In